All right, the next case on the court's docket is 10-22-00266 CV, James versus Thornberry. Appellant will have 20 minutes to open. Counselor Elam, you may proceed when ready.
Thank you, Your Honor. Good morning. I am attorney Taisha Elam, and I am here for the appellant Ann Johnson James and Lois Johnson Warren. We're here to discuss whether or not the partitioner, Jonathan Thornberry, had standing to partition the property when he acquired title to the property from an unrelated person. There is a new statute, well, relatively new, of course, chapter 23A of the Texas Property Code, which is the Uniform Partition of Heirs Property Act. And this act requires that a person that is interested in partitioning property from heirs acquire title from relatives. So the court will be able to assist others in determining whether a person who buys an interest in property from non-relatives actually has standing to sue on that behalf.
Counsel, when was that statute passed and will it be applicable to this proceeding?
It was passed in 2017, and it is applicable to this proceeding because it is intended to govern any action brought to partition property after the enactment. This action was brought in 2019, long after the statute was enacted.
All right, thank you.
Thank you. There are additional points of error to address the validity of that partition order. That partition order was signed after a brief hearing that we had in the court where the parties and I, the other co-counsel and myself, we determined that the appointment of commissioners might help us determine whether the property could be properly partitioned. That is a tongue twister. However, the court at the end of the proceeding, according to the transcript, decided, yes, we can appoint commissioners. We'll see if they can determine some fair ways to partition the property. We'll wait on their report and we see where we go from there. However, a couple of days later, while I was on vacation in Fiji, I received a call from the court, from the judge himself, that called to say that he had spoken to Thornberry's attorney and that he was going to sign the partition order, granting partition in kind, over any objection. So the question is whether an order can be enforced or whether an order is valid if it is signed after ex parte phone calls rather than an evidentiary hearing. The third point of error that I'd like to focus on is whether or not the order is valid when it was an attempt to partition property based on an unrecorded heirship judgment. The courts have held since the 1880s that interest in land must be recorded in the real property records. In this case, the action was brought in 2019, but the judgment that it sought to enforce was not recorded until May of 2022. So the appellants would suggest that the partitioner lacked standing to enforce an order that wasn't even recorded. Do you have any questions about those points of error or move on?
No, we'll pick them up as we go along.
Okay, thank you, Your Honor. The question, if the court determines that the partition order is valid, even though the interests were obtained by non-related persons, then the question is whether the order granting them an interest was valid as well. There's an heirship order that was signed in 2011, filed in 2010, that was brought by the surviving spouse of one of the heirs to the Johnson estate. The law has held that in order to seek the determination of heirship, a person must be interested. In this case, Jim Johnson passed away in 1947. The applicant, Charles Mack, was 8 years old. She had not met her husband. She had no knowledge of any Johnson heirs. So clearly she lacked standing to probate his estate, some 60, 70 years later.
Counsel, in the heirship proceeding that was filed, it traces out the heirship far beyond Jim Johnson's, heirs. Do you know why it was done that way?
If you'll ask it a different way, I may be able to answer your question.
What is supposed to be done in an heirship proceeding?
In an heirship proceeding, the applicant is to petition the court to determine who the lawful heirs at law are to the property.
And at the time that Jim Johnson passed away in nineteen
Yes,
forty-seven.
thank you. Yes,
He had
correct.
6 living children.
Correct. Yes,
Okay.
Your Honor. Thank you for clarifying your question because that is a key point. That yes, the application to determine heirship should have determined who the heirs were at the time of his passing. And this heirship not only fails to do so, it adds additional strangers and unrelated persons and grants them an interest.
Now, you provided in your briefing, 2 different family trees.
Yes, Your Honor. I
And,
brought them again as well.
I think we all have copies of them on the bench. The one that you refer to as the family tree, you show your clients as being the owners of 100% of, at this point, I'm assuming 59 acres?
Correct. Yes, Your Honor.
Okay, is where your argument is. Why is it that the other heirs' interest, why do you contend that they were not able to convey their interest in the property? By death or just by distribution as part of a testate, administration of an estate, or by a conveyance?
Yes, let's go through that. So Susie Johnson Pitts.
Well, I don't want to go through the details
Okay.
of the conveyances. I want to know the theory of how it is that it all comes to your clients.
It all comes to my clients because they're the eldest living descendants of Jim and Nancy Johnson.
Okay,
The
I want to pursue that for just a moment.
Yes.
But then I want to come back to the general descent and distribution of property.
Yes.
Is it your contention then that whoever passes first, Anne or Louise? Is that? Yeah, Lewis. Okay, so whether it's James or Miss James or Miss Warren,
Mhm.
whichever one passes first, their interest goes to the survivor.
Their interest, there's a right of survivorship if that person has no heirs.
Where is that in the law, the right of survivorship? Because one of the things we struggled with is it seems like your argument is built on a theory that this is started off joint tenants with right of survivorship in the 6 children of Mr. Johnson. And that because they are the last 2 surviving children at the next level, they somehow have acquired 100% of the title of the 59 acres. And I'm having trouble with the origin of that theory.
Okay, I don't want to say that there's a right of survivorship because they're the last survivors. There's the fact that the remaining siblings had no heirs is the reason why their interest passes to them. So like,
but like Miss Mack, she acquired hers by devise from Annie Mack.
But she did not.
Or I'm sorry, it may have been by Herman Mack's will.
He had no will.
Okay.
If he had a will, we wouldn't be here.
But he died. Mr. Herman Mack
Correct.
died while
Correct.
while Ms. Mack was still alive, correct?
Correct.
Okay,
And if he had a will, that's the perfect way to think about it. If he had a will, he would have been able to give his interest to his spouse. And she would have been able to probate the will, we wouldn't be here. Because she would have gotten what she wanted. What she wanted in 1989, when her husband passed, was the same interest that Ella Faye received. When Ella Faye died, she was the first surviving spouse of a deceased heir. When Ella Faye died, the remaining siblings deeded her husband's interest. And so,
I've got a question,
No.
and I don't mean to
no,
interrupt, but Ms. Charlie Mack, wouldn't she have received Mr. Herman Mack's share, whether or not he had a will?
no, if she had children, her children, but back then, we have to remember the context and the timing. Back then, the surviving spouse had a life estate. The property passed to the children. Charles Mack went through all of this because she did not have an interest.
So you're looking to intestate succession statute?
Absolutely.
To guide this.
Correct,
Okay.
correct. There is no will. Correct. If he had a will, like I said, we wouldn't be here. If he had deeded his interest to her, she wouldn't have stolen it. Yeah.
If Herman did not have a will,
Mhm,
he left a surviving spouse,
mhm.
and you say no children.
Well, he had children. He had 2 children, but they've since deceased.
Well, but they weren't deceased at the time he passed away.
Correct.
So he died with surviving children and a spouse.
Yes, there we go. Yeah.
Okay. Now, if those children, if Ms. Mack had a life estate
Mhm,
in Mr. Herman Mack's interest,
mhm,
those children then upon her death
mhm.
would receive the remainder.
Exactly.
Okay, but they're gone.
That's correct. You got it.
Okay.
That's correct.
Okay. I didn't think the probate code in this regard had been amended. Since the memory of man runneth not to the contrary, as Angus McSwain would used to say. And I don't remember from the heirship affidavit, and the fourth amended application.
Mhm.
There were some people that died with wills, as I recall, and devised their property to different people.
Don't think anybody passed away with a will, and no one passed away with a will giving an interest. You may be thinking about her suggestion that in order for Helen Mack to receive an interest, and I'm gonna go really slow because it's very complex. In order for Helen Mack to receive an interest, Charles Mack, in that affidavit of heirship, she says that Susie Pitts was married to Jesse Pitts, and that Jesse Pitts inherited a life estate in Susie Pitts' property, and that he gave that life estate to his friend Ann Robinette, and she had a child who was Helen Singer.
But, and I don't have the various iterations of the laws of descent and distribution memorized, but I thought that Mr. Pitts, as alluded to by Justice Johnson, would have inherited under the laws of descent and distribution a portion of his wife's separate property.
He just gets a life estate. Unless she deeds it to him, unless an heir deeds their interest, that is separate property.
And I don't want to complicate it more,
No,
but and apparently the intestate succession statute has been amended over time. Do you think that the title to the property would pass in accordance with the intestate succession statute in effect at the time of the death?
yes, and I would say this, that the timing is irrespective, because these people are strangers no matter when you probate.
Well, unless they required a title by a conveyance, either from an heir, either through a will or intestate succession, where it went to a surviving spouse.
Correct,
But, and then they would have an interest that they could convey to
correct.
Mr.
Correct.
Thornberry.
Correct.
Yes, Thornberry.
Correct. And so the only way that, so let's talk about the three different strangers, okay? So you said it perfectly. Had Herman Mack had a will and given his wife by probate of his will and interest in his property, again, I argue we wouldn't be here. Because she would have received what she wanted. She would have received an interest in her husband's estate. She would have found a lawyer in 1989 or 1990 that would have probated his estate. She would have gotten her interest, and everybody would live happily ever after. But she spent 20 years trying to find an attorney that would probate an estate of her in-laws and give her an interest that she did not receive. So that's her, okay? In order for Marlon Reese to receive an interest.
Herman had children
Mhm,
at the time that he passed away.
correct. And if you want to think about it, those children at the time of his passing were 6 years old and I can do the math, about 13.
What happened to their interest?
They would have had an interest when they survived, and it would have passed to their heirs, but they passed with no heirs.
But the one son of Herman had his estate probated. Did he not?
I don't recall a son of.
Well, the affidavit of heirship says Gregory Mack's estate was probated in the probate court of Galveston County, Texas. Obviously, we don't have that in front of us to show
What it showed.
who might have been one of his devisees or what he might have devised to them.
Mhm.
But it's not totally accurate to say, Marlo Denise apparently never married, had no children. And so that takes care of that. But her brother apparently did have a will when he died, and that will was probated.
Or his estate was probated.
Yeah.
Because what Charles Mack also did, and I didn't want to tell you to further convolute it, but she attempted to probate her husband's estate in Harris County with no nexus, to Harris County. She attempted to, try to slide something in, to Harris County, but it didn't work.
Well, you said it didn't work. It was apparently probated. And that judgment, as far as the judgment, is still out there. Hadn't been set aside.
True, and I don't know what it says, because it's so old that the archives won't let you see it, so I can't see what it says.
Does that go back until 1994? Because that.
Online.
Online, I guess. They haven't scanned things in as recently as 1994, because he apparently died in January of 94.
Well, he died in 88.
I'm
One of
talking
the
about,
children, one of the children died.
I'm talking about Gregory Allen
Oh,
Mack,
yes, yes,
who was
I-
Herman Mack's son.
If that you probably can find. And I would venture to argue that let's pretend that we do find it, okay? And let's pretend that, that does give her his interest, okay? Let's argue for argument's sake, that it does give her an interest. Then that gives her standing, of course, to apply for, an application to determine heirship. So I would have no problem if that document reveals that that's what took place. But then we have to reach and determine whether or not the court, that order is allowed to transfer an interest to Marlon Reese and Helen Singleton. Because those are two people who, no matter what we construct, the court had no personal jurisdiction over them. They were not served regarding the proceedings. They did not appear at the proceedings. Marlon Reese is a gentleman that lives in, Missouri, I believe. And, he was babysat by Bernice Spriggs. And, he was approached by Charles Mack to participate in this action. Now, she did it, or she approached him, we don't know when, but long before she actually filed suit. She didn't give him notice of the suit. She didn't tell him what she was alleging. She claimed that he was adopted. She claimed his name was Marlon Spriggs. But after contacting him, I determined his name is not Marlon Spriggs. He was never adopted. And when faced with all the evidence of what was going on, he revoked his deed. And so I want no parts, of this,
But the deed's still been signed and executed, and if he has a
Yes,
interest, there's an issue.
yes.
Here's fundamentally where I'm confused.
Yes, Your Honor.
A lot of work's been done on airship tracking this through in the airship proceeding. And at least based on my recollection of what the laws of descent and distribution were, I'll just say at the time I went to law school forward, I don't remember these changes that you've referred to. And I'm having a hard time tracking through the specific percentages and that everything winds up with your clients. The math, I'm gonna go back through the math, go back through the statute, but the computation, I'll put it this way, I understand the computation of the ownership interest as done by the appellees that I know that you completely disagree with. And obviously from just this meager effort that we've done here, there's no way we can sit here and walk through this. But bear in mind how complicated it is in trying to show us who owns what and whether or not those statutes are interpreted the way you have argued them.
And I would agree with you 1,000%. And what I would encourage or ask that the court consider is the fact that while we may have difficulty determining what Charles Mack owns and her percentage, we have no similar difficulties with respect to Marlon Reese and Helen Simmons.
Well, see, I look at it as a different way. I look at it as I can very easily recompute what Mr. Thornberry contends your clients own, being 15% each. I don't see the math flowing through on a joint tenants with right of survivorship type estate, because that's not the way the probate code is written, now state's code. And so that's where we're struggling.
Yes,
You'll have 5 minutes in rebuttal.
yes,
I'll come back to you.
okay.
I'm gonna try to give you 5 minutes uninterrupted by my questions. I'll leave it to them to ask anything during that 5 minutes. And then I'm gonna go down another path, but you may proceed.
Ms. Elam.
Go ahead and give your name since we're doing.
Oh, I'm sorry, Warren McCollum for Jonathan Thornberry. May it please the court, Ms. Elam. I guess where I want to start, and I'm deviating from where I was going to start, giving a background about the case and those type of things. And it's probably appropriate that Jonathan Thornberry bought the interests of Charles Mack, Helen Singleton, and Marlon Spriggs based off of a heirship judgment that was issued in 2010. And that date's very important here because under the estates code, I think it's 202.203 or 202.202. It says that in order to challenge one of these judgments, you have to challenge it within a 4-year time period. By bill of review after that, okay?
I'm gonna have to break my promise.
Okay.
I don't even think I made a minute, did I? Okay, because this is where, I know you don't know how we do this, but we meet and talk about these cases and that judgment is in a county court at law.
Yes, sir.
It determines heirship, but it does so much more than determine who the heirs of Jim Johnson is, who are his 6 kids. If this had been done in 1947, when he passed away, we would have had 6 children. County courts at law normally do not have jurisdiction to adjudicate title. And this county court at law adjudicated the title to 59 acres.
And I don't disagree with you. I will tell you right now, I'm not prepared to debate on the issue of whether the county court of law has jurisdiction.
And that's why I'm giving y'all a briefing assignment of whether or not that judgment is void.
Okay.
Based on the jurisdiction of the county court at law to determine title. Now, I think the firm did an incredible job of walking through and determining ownership. And that's why I spent the 20 minutes with opposing counsel trying to figure out the theory under which her client owns more than the 30% that Judge Hale derived after looking at all of this. Because I can tell you, Judge Hale spent a lot more time doing probate work than we collectively have. But the problem is, did she have the authority in 2010 to issue that judgment? And then what happens? If she did not have the jurisdiction, is it void? Useful work that may just transfer over wholesale into district court, but is it a valid judgment? And if it's a void judgment, it's a void judgment.
I do think with some of the smaller counties like Walker County, I know there's an issue with the county court of law having probate jurisdiction and there being some sort of concurrent jurisdiction. As you know, I don't know the answer to your question off the top of my head.
That may be a valid distinction, normal county court at law versus county court at law as a probate court.
Right.
And we need some understanding of that. Yeah, I'm sorry.
I've always understood, because I was a county court of law judge before I was a district judge. And I always understood that the concurrent jurisdiction only extended to probate matters, as opposed to what I would call title matters.
Okay. But there's another important point here. This is not something that she ever raised in any briefing.
It's our jurisdiction, it's trial court jurisdiction, void judgment.
Okay, so she doesn't have to raise this in her appellate arguments, or she would.
She challenged the validity of that judgment, which caused us to go down the path. But when we tripped to the question of is the judgment void, then we had to ask ourselves the question, can we decide this appeal? What is the effect of that? What is the effect if, was this Hal Ridley's case?
Yes, yes.
Yeah.
If Hal applied the judgment that Barbara Hale had signed, as you have argued for, And like I say, the math, I kind of understand. But my problem is how can Hal rely on a judgment that the trial court had no jurisdiction to issue? And I don't know the answer to that question.
Well, I think under the estates code, there's a specific time period under which to challenge the judgment. And that was never done.
Agreed.
They were given notice of it. In the record, we provided the entire record from the county court at law. They were given notice, and even after that 4-year time period, they didn't challenge it. And
But does the failure to timely appeal a void judgment somehow make the void judgment not void?
If you think back to our first case today, the first thing the attorney argued was a late notice of appeal. Late notice of appeal, no jurisdiction, can be raised at any time. My concern here is that we've got a judgment from a county court at law that appears to adjudicate title in 2019 as opposed to determine heirship in 1947. And I'm not telling you how this comes out. I don't know. And that's why we're asking for help on the briefing of that impact. Because as I understand it, your argument on appeal is that you are relying upon that judgment from the heirship proceeding that shows your client owns 70% of the property.
correct.
That would lead us exactly where the first step of most partition proceedings are, which is a determination of who owns the property about to be partitioned. And then the second step, which is where we seem to be, is it capable of partition in kind, which is dependent upon that first determination. And it seems like we sort of skipped over that first step in this partition proceeding unless you can properly rely upon that judgment. And that's where we need some briefing here. And I realize I have thrown you a curve completely that you weren't anticipating, and I'm not asking you to
Well, I was looking
address
at
it extemporaneously.
I have the estates code up, and so I was looking to see if I could see anything in here, and off the top of my head, I'm just not trying to read it and listen to you.
I think our question, I mean, whether it's void or voidable is the question.
Right.
And whether, if it wasn't challenged pursuant to the estates code or probate code in effect at the time, does that, if we can evaluate our jurisdiction, make sure that we have jurisdiction to hear a case, but we have jurisdiction to hear the appeal that's before us. And so my question is, just because there's a potential that we have a void or voidable judgment below that the trial court's decision in this appeal was based upon, is that something that we can challenge we can examine the jurisdiction of? Because our jurisdiction is fine with regard to what's being appealed today. And so is that a fair evaluation of our jurisdiction? Or is that not a situation in which we can examine and evaluate our jurisdiction? Because underlying document, it may have been all wrong, but the judgment has been entered, that judgment's never been challenged, and it wasn't challenged on these grounds in this appeal. So I mean, I think those are the things I'd like to see. If we're doing additional briefing, those are things that I think would be important.
And what Judge Johnson's drawn the distinction of is in the first case on the notice of appeal, that's our jurisdiction directly.
Right.
The notice of appeal is what invokes our jurisdiction. I don't think there's any question that, as Judge Johnson said, we have jurisdiction of this appeal. It was invoked by a complaint about the order ordering partition. That order is in effect based upon something that happened in the trial court that determined jurisdiction. Actually, in this order, ownership is, I said jurisdiction, I meant ownership. The ownership is determined in the same order
Right.
or announced in the same order. But that's relying upon that. County court law
Yeah,
judgment.
I'm with you. I understand the
Okay.
significance of the airship
And
judgment.
the distinction that Justice Johnson was trying to make, and making effectively of between our direct jurisdiction and a proceeding that may be based upon a judgment that was never challenged, not timely challenged, that would have affected the ability of the trial court to do what they did. And specifically, you know, we're all in the state, we're big on finality of judgments. That judgment is still sitting down there in the county court at law. It has not been attacked in the county court at law. It is still on the record in the county court at law, although there's an argument about whether or not it was timely filed over in the deed records. But
Well, and so you understand, and you'll see this in the clerk's record, they did attack that judgment in the county court of law. They filed an application, they tried to open the probate. And we
through the
challenged that.
nephew, yes.
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 Challenge that. And the court denied their application.
Was that application filed in the same proceeding or a new proceeding?
It was in a new proceeding at the county court at law.
Okay, so the actual judgment in the county court at law has not been overturned or,
It has not been overturned.
okay,
She also filed a bill of review, but she filed that incorrectly, and I can't remember the rule now. The bill of review, I think, has to be in a new cause number, and she filed it in the same cause number, and we raised that issue, and the court dismissed it, plus the fact that it's well past 4 years to file a bill of review. But I'm probably gonna read back over, my understanding this is being recorded, so I'm gonna have to go back over it to make sure I understand everybody's question. But if I get it correctly, your question is, do we have jurisdiction to look at another judgment? Your question is, this judgment is the evidence upon which my client is basing his interest in the property. If that judgment is void, how does that affect my client's interest in the property?
I hadn't really thought about it as being the evidence of, that may be a different question. My question and his question are the same. He articulated it better than I did.
Okay, so the issue is whether y'all have jurisdiction to look back at a judgment from 2010.
Well, mine's not quite that question. Okay, let me try to refine it a little bit. We get a notice of appeal in a case and we decide that we don't, let's say inappropriately here, we don't have jurisdiction. Nobody raises it, but the case just shouldn't come to this court. We can always evaluate our jurisdiction and decide, dismiss, want a jurisdiction. Okay. The thing I'm trying to say, is Judge Ridley's order has now been appealed up here. We have jurisdiction over that. I mean, we can evaluate that issue now, whether it was properly entered, and does the fact that an order was used in Judge Ridley making his decision that might be void or voidable, whatever way y'all want to look at it, is that a jurisdictional issue at this level when what's actually being appealed is Judge Ridley's order, not the county court of law order? And so we can all, and what I'm trying to get at is that you said, well, can y'all raise that yourself, sua sponte? Well, we can if it's the jurisdiction in this appeal. But the documents, the order that's being appealed here, we have jurisdiction over. And so do we get to evaluate jurisdiction in a proceeding that was done in 2010? And if it's void or voidable, I mean, we can examine our jurisdiction. I keep saying that, so I apologize. But does the double layer here is really what we've got?
Yeah.
Is that something that?
And I don't know that I should encourage this, but courts of appeal oftentimes like to sidestep issues for a later day. And there is a way to sidestep this issue. And if you read my brief in full, I acknowledge the fact that this needs to be remanded. Because Charles Mack, who deeded her property to my client, reserved a mineral interest that I missed. And the case law is clear that all interest in the property must be a party to the suit. Now, she was a party at one point when Miss James and Miss Warren counterclaimed against her for quiet title and fraud. But she was later dismissed, and you're not going to see that in the record. And the partition order does not involve her, because I didn't appreciate the fact that there was a mineral reservation in there. And the case actually needs to go back down, and the relief that she sought is basically to undo that partition order. She wanted the partition order to be thrown out. And as I acknowledged in my brief, she's actually entitled to that because Ms. Mack was not a party to that. So, and I have been handling this issue in other partition cases since, and the way I deal with it is I only seek to partition the surface estate. And that's what I intend to go back and do at the trial court, is to partition just the surface estate. But what this raises for me is that I would almost prefer y'all answer the question. We have this additional briefing because I'm confident that she will appeal once again and raise these same arguments and probably do a better job at the trial court of preserving the error. So I know I'm just giving you an out, but that is one thing that I've acknowledged in my briefing, is that it actually does need to be remanded.
In other words, on the remand, you can, in effect, prove up in the district court what was previously proved up in the county court law. And prove title again, is that what you're suggesting?
That's actually not what I'm suggesting.
Okay.
Because you have raised this issue for the first time, because I look at that judgment.
Oh, let it go down there and let Hal deal with the question first.
Well, Hal can deal with the void judgment issue.
Okay.
And frankly, he already has, because she's raised that issue. Now, she never raised jurisdiction. She may claim otherwise, but she never raised jurisdiction of the court to actually determine the property interest.
The county court.
Correct. Okay. But what I'm saying is I have a defect because Charles Mack was not a party to the lawsuit when she owned a mineral interest, and I didn't limit the partition to just
The surface.
the surface estate. And in my briefing, I cite to a Tyler Court of Appeals case that deals with this issue, and remand is actually proper. Now past that, I think the way I fix it is I amend my petition so that I'm just dealing with the surface estate. We partition again, just the surface estate. We have commissioners appointed, and then she has the opportunity to appeal once again. And we deal with this issue, or Hal deals with the issue. I'm sorry, Judge Ridley deals with the issue.
It's okay.
At the trial court.
Okay.
I still have a minute. I'm sorry.
You still have a whole minute.
Do you have any more questions?
And we haven't touched on anything yet. You understand our confusion, the complication. My concern is if generally this thing is a bust because of the reliance upon the 2010 airship. I don't want you thinking that we agree with your understanding and the theory of ownership at this date. Because looking at the airship affidavit and the law at the time, to be very candid, I understood where Mr. Warren came up with your clients owning a combined 30%.
And that's the only thing I want to speak to in my rebuttal.
Okay,
Can I have just
you
30 seconds?
you take a couple of minutes, 5 minutes, whatever you think that, we've thrown you a monumental curve. We didn't throw it to her, because it was the judgment. So you take what time you need. I'm gonna put 5 minutes on the clock.
Thank you, Justice. The issue with Charles Mack and her ownership interest, this is my understanding, and I am not, so you understand my black background, I primarily do personal injury defense. In fact, when the other side was up here arguing, the other case was arguing the arbitration issue, I felt like I should have switched sides with them because I deal with that all the time. But my understanding is Herman Mack is married to Charles Mack. He passes away. He's got 2 children. They both pass away. It's my understanding that neither one of them had children. And under the heirship statute, she is next in line. So because of that, that's how she has her interest in Herman Mack's property.
But by the way, the heirship affidavit says that one of those kids had a will that was probate.
Yeah, I've got it here in front of me, it's clerk's record 136, it says his estate was probated under cause number in the probate court of Galveston County.
Yeah, so what I'm trying to say is there may be somebody that you don't even know out there to whom he has given whatever he had.
He may have given his part to the child of Herman and Charles Mack, may have given their interest to Bernice Spriggs.
Exactly.
Just as,
Just what I'm
But-
saying is that particular individual, when you say Charles Mack, whatever she may or may not have gotten from her husband, one of the childs died intestate, and so it goes back under intestate succession. But you've got an heir somewhere, theoretically, out there that's not even in here.
I don't, as I said, I don't do a lot of probate work, but when I see the term probated, I typically associate that with wills, but I also know you can do
Administration.
small estate administration, there's
I'd want to see whatever order that judge signed in that probate case.
understood and agreed.
so basically, under your theory, so that I understand, it went from Annie Mack, the daughter, to Herman Mack, the grandson, to his children, subject to the issue and then back up to Miss Mack, to Charles Mack.
Yes,
That's how she wound up with her.
that is my understanding of how the heirship statute.
Whatever
works.
interest she has. Yeah.
Yes. Now, now her argument is Miss Mack didn't have standing. This record, and it is not an affidavit by Miss Mack, it's actually by a woman by the name of Gladys Goffney. Even under the vague issue or the issue we have with the estate of Gregory Allen Mack being probated, Marlo Denise Mack, it indicates she had no children and an affidavit of heirship was filed. So Miss Mack in this situation would at least inherit Marlo Denise Mack's interest in Charles Mack's portion. So she
I have
doesn't stand.
no issue with that. I'm just saying that she doesn't get everything that Herman would have had.
Depending on what
Depending upon what her son, or what the
Yeah.
son,
Did with
will
his.
did with that particular interest.
Okay, did you do what you wanted to do in your 5?
I would encourage you to review her brief carefully and look to whether it's actually supported in the record, because there was a lot that was said here. I'd say about 75% of what she said is not in the record anywhere. A lot of what's being argued is outside the record. And that was a lot of my briefing, is that there's no case law to support some of the things that she's wanting, and there's no record of her even presenting this to the court. For instance, the alleged ex parte conversation. That's nowhere, that's the first time I saw that was in her brief. So I do think, please look at that carefully if we get past the issue with the 2010 judgment and jurisdiction.
Okay.
Thank you.
Thank you for your time, your patience with me, on the questions.
Us.
Well, yes, it's all of us, but, we are,
In 50 years, I'm sorry, 50 years, 25 years of practice, this is my third appellate argument.
My second.
but given that it did not go the direction that you had prepared for, y'all both done very good. So, you've got 5 minutes of rebuttal.
Thank you, Your Honor. I want to just highlight the fact that if we clarify or attempt, by briefing and research to clarify what Charles Mack had, that's the biggest battle. But the easy part is determining what, Marlon Reese and, Helen Singleton had. So I just want to say that we almost are forced to toss out that 2010 judgment, because no matter how whatever we determine is incorrect. Whether it's incorrect based on fraud or error is incorrect. And it's not fair to his client and not fair to my clients to enforce it in any way. If we are able to successfully, let's argue that it's valid. Let's argue that I stink at briefing, and that it's valid. Then we're gonna be able to take a look at the will, take a look at her son's will, go back to the statute, determine what the intestate laws were at the time that he passed, determine what her interests are based on, then we have to determine, are we basing it on who the living heirs were at the time? We get to go through all those gymnastics. But what we do know for certain is that Marlon Reese had no interest. Well, we know.
But you understand that under the computation that has been made, if that county court at law judgment is valid, and I say valid by meaning not subject to being attacked at this point, it doesn't matter, because that judgment's been on file for 14 years now.
Correct.
But even if it can be attacked, that may not change the percentage ownership of your clients. It may go somewhere else.
Correct.
Okay.
Correct. I totally
Okay.
agree. And just to piggyback on that point is that I think it's important to determine, what he owns so that we know what everyone's interests are. So my goal will be to brief with the goal of determining whether that order is void or voidable, and also to do the calculations so that in my brief, I would argue what the valid interests of all parties are. You know what I'm saying? Not to just
I do.
address the void or voidable. I'm gonna overreach. I'm gonna try to kill two birds with one stone. I'm gonna brief on whether that order is void or voidable based on jurisdiction, but I'm also going to piggyback it with other reasons it may be void or voidable. And to get an A in my class, I'm not gonna have a class, I'm just joking. But I will also attempt to calculate to the court what those purported interests would be. But like
Heavy emphasis on probate statutes, on the laws of descent and distribution, if you're going to go there.
Correct.
I'm not sure we need to go there on this round of the briefing, but if you start getting into tracing or calculating out interest, I need probate code sections,
yeah,
because I don't remember those sections changing over lifetime.
yes,
I mean,
sir.
they've been the same since it was pre-revised civil statutes, is my recollection. So.
Thank you. And I do wanted to thank Mr. McCollum, because he actually brought up a point that I had written in my notes as well, is that I too was under the impression that a application to determine heirship does not determine title. I didn't say it the way you said it, and I didn't think of it the way you guys are thinking of it, but I was under the impression that an application to determine heirship does that and only that it determines who the heirs are, and that an administrator is necessary to distribute title. And that's why, like he said, I filed an application in the court because I said an administrator is necessary for the Jim and Nancy Johnson estate to challenge who the heirs are. We have to have an administrator. So I sought that appointment, but I lost. But I sought it because I understood that judicial determination of heirship only did that. And that if there was any proceeding with respect to title in his property or their property, an administrator has to attack that and distribute that.
Questions?
No, sir.
Questions?
May I have a minute?
Yes.
I'm reading straight from the, section 202.201. The judgment in a proceeding to declare heirship must state, one, the names of the heirs of the decedent who is subject to the proceedings, and the heirs' respective shares and interests in the decedent's property. That would seem to answer our question in that the probate.
Okay, we're getting beyond, we're opening up the argument on the effect of that judgment. I don't want to go there at this oral argument. I need you to brief that. I understand where you are on that. If one of these children, one of the six, had passed away before Mr. Johnson, there could be multiple in 1947. Everybody has a sixth, but if, say, Preston had 3 children in 1947, when his father passed away, then you would have to say a third, and a third as to the sixth. What it doesn't address is my understanding, and this, you'll want to take this on out. I understand that. It's not where does the survivor's interest wind up on the date that it is
I
been determined.
I understand what you're saying. What you're saying is that the statute clearly says you can adjudicate the first 6.
First
It's
layer.
Once you get past that, I'm with you.
Who are the heirs on the day the decedent
Yeah.
died? It could be grandchildren.
So it's when you get past that, that's where you're questioning based on the estate code, whether it has jurisdiction to go past the first 6.
Well, not just go past the first 6, but to say, and he owned this piece of property and these people now own that property 50 years later.
Yeah.
It's in 1947, and the thing that we didn't even talk about yet is Nancy.
Oh, yeah.
No, we're done. We're done talking.
Yes, sir.
But in 1947, each of these 6 children owned a 12th. They didn't own a 6th.
Right.
Not until 1960,
Four.
not until the 1960s did that change when Nancy passed away and they got a second 6th,
Right.
or excuse me, a second 12th. So that they then owned a 6th. And that wasn't in the briefing at all until we got to the response.
But they did an heirship judgment on Nancy as well.
I know.
Okay.
What's interesting is both heirship judgments determine total interest, not even the half, if you will, the community property act. But we don't need to go there. I think y'all understand what we need briefed. And now let's talk about timing. It's gonna take a bit, is what my colleague just whispered in my ear. First of all, this is on YouTube. It will stay on YouTube. You can go back and see what the issues are that we talked about, so you can do that. And if you need to know the YouTube channel, you can't find it, check with the clerk's office and they'll send you to the YouTube channel. 60 days from today. You'll have 30 days after her 60 days. And subject to further order of the court, after I talk to these guys and see what, where we may go. So, anything else before I close? All right, this case is submitted. Y'all are excused. Thank you for your time. Very unusual arguments. So thank y'all.
Thank you.
Thank you.
Thank you.
Have a safe trip back to Houston and Lufkin.
Thank you. Appreciate it.